The sheriff's office.
Regarding whether non-attorneys can have conversations with persons held at the jail that are not monitored.
They're absolutely prohibited. Those conversations are absolutely prohibited.
All right. Who is here from the jail?
William Castile.
All right. I think I need to understand two factual things, Attorney Bradl, before we go on, which is it the policy, rules, and procedures of the jail that only communications with attorneys are unmonitored? And I want to know about the limitations on other communications with other persons other than the fact that they are monitored. Length, duration. Okay? Any objection to my taking that evidence?
I don't have an objection. I just want to invite the court to keep in mind that the issue is what is my state of mind about what the rules are and what I can do and can't do, and what is disclosed and not disclosed. So,
I understand. There are also requests that I take some action vis-a-vis the jail, and so I want to understand what the rules over there are.
Thank you.
Okay? Thank you, officer.
And Judge, just for the record, I had no notice that there was any witnesses being brought in.
I understand, and
that there was an evidentiary hearing at all. I think that's extremely unprofessional to ambush me with bringing a witness into the jail that I may have been able to have a conversation with before this.
I appreciate that. I am going to inquire of this witness because I need that factual information. It is not an evidentiary hearing in the sense that it is going to be full-blown inquiry. Okay?
Thank you.
Sir, can you raise your right hand? Do you solemnly swear the evidence of the court in the case now in hearing to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, can you just state your name for me?
Sure, it's William Castile.
And what is your role at the Norfolk County House of Corrections?
I'm an assistant deputy superintendent.
All right. Can you answer this question for me?
Sure.
What is the policy or rules or procedures at the jail regarding unmonitored phone calls? Are those limited only to attorneys, or does it include paralegals and or?
Yeah, it's just strictly to attorneys.
Strictly attorneys?
Yes.
Okay. So if an attorney identified a paralegal and a person at the jail communicated with that paralegal, they would be monitored conversations?
They would be, yes.
All right. And what limitations are there on non-attorney phone calls at the jail in terms of duration, time, number?
Sure. So it's 30-minute telephone calls. And the time, they have tablets now, which they can make phone calls, they can e-message, they can receive videos, they can receive photos, and the tablets pretty much all day.
So all day?
Till 10 o'clock at night.
Okay, all day access to the telephone?
Yes.
That is monitored?
Yes.
Okay, and the rule again at the jail is that only communications with attorneys are unmonitored?
Yes, our policy is CSD 482. I have a copy here if you'd like.
No, I will take your testimony. I appreciate it.
You're welcome.
I don't think I'm going to permit any further inquiry because those are just the facts that I needed to understand in connection with these motions. Thank you very much. All right. Attorney Mello, anything else you want to bring to my attention?
Your Honor, I was going to ask Mr. Castile, while he's still here, if the court would grant permission for him just to play the recording of Attorney Bradl making this call to the jail, so Your Honor could actually hear it.
You mean the one that is in your motion?
Yes.
I do not need to hear that.
Okay.
Thank you. Thank you, sir. All right. Anything else then?
Well, one other quick, because Attorney Bradl made the comment, Judge, that he called the jail to take these people off the list. I would ask if that...
Hey, that's a mischaracterization that I called to take people off the list. I never did any such thing, Your Honor. I don't know what he's talking about.
That is certainly my understanding of what he's...
All right. Both of you take a seat. Both of you. Sir, if you could retake the stand. Did the folks at the jail learn at some point that Ms. Altman and Ms. Healy were not attorneys?
Yes.
And when did you learn that? Or when did the jail learn that?
Around January 11th.
Okay. And has the jail taken steps with respect to phone calls between Mr. Carney and Ms. Altman and Ms. Healy?
Yes, we've removed them from the attorney privilege list.
Since January 11th?
January 11th, yes.
Okay. And how did you come to learn in particular that Ms. Altman was not an attorney?
Actually,
received a request from the Norfolk DA's office for Aidan Kearney's call detail log. I sent that over, I scanned it, emailed it, sent it over. A couple hours later, I received a call from one of the troopers stating that, you know, I may want to take a look at my attorney client privilege telephone call list in particular to inmate Kearney, offender Kearney, I should say.
Okay.
And that's what got the ball rolling.
Okay. Thank you.
You're welcome.
Thank you. All right, Attorney Mello, anything else you want to bring to my attention in connection with your motion?
Other than, Your Honor, the fact that it was discovered by the jail, in the messages Your Honor has, I believe in that set, there's a note that Ms. Altman had told Attorney Bradl twice that she was not an attorney. Mr. Bradl asked the question, did you tell me that before or after I called the jail? Either way, he was aware that and he never called the jail to correct it once he found out.
Okay.
So I'm going to suggest, Your Honor, that that is an attempt to circumvent the authority of the court to have Mr. Kearney held in jail under the terms and conditions that the sheriff normally imposes on jailees.
All right, I appreciate that. Attorney Bradl.
Thank you very much, Your Honor. With respect to this assertion about...
I'm sorry, thank you. Thank you, officer.
Judge, with respect to this assertion about Ms. Altman, that conversation, those conversations when she told me she wasn't an attorney, we were just discussing who she was and I was getting to know her about her role here. And she did tell me at the time that she wasn't an attorney. However, I didn't even remember that I mentioned this call. Now that it's under a microscope, of course, it's out there. But when I spoke with Ms. Altman about those issues, I was confused about, you know, when do we talk about that? Because I knew I would never have said that to Captain Linsky on the phone if she told me that beforehand. So since then, I have absolutely ascertained that those conversations were weeks later that she wasn't an attorney. She did tell me that, absolutely. But I didn't even remember that I mentioned that to Captain Linsky on that voicemail weeks prior that, oh, she's an attorney, she's a paralegal. So more to the point, Judge, rather than what the jail's policy is, the issue here is what was the interactions? And all this is laid out in my affidavit, Judge, and in my motion. And that's exactly what happened. There's nothing here but an honest mistake. I was, at the time, I got 3 folks from the civil side of this thing where Ms. Dombrowski, and you have her letter there, she's working on the First Amendment aspects of this case. And the First Amendment aspects of this case were starting to arise, Your Honor. And so Mr. Kearney arranged and Ms. Dombrowski have 3 people to help me with the First Amendment. After that, Mr. Kearney got incarcerated on the bail revocation. And I've been speaking, and they all speak with Mr. Kearney. And so I'm not 100% familiar with the rules about attorneys or paralegals or investigators or who's allowed and who's not.
Well, we all now know, only attorneys.
Yeah, right. Certainly now we know. But at the time, my practice would be to just make sure my phone numbers are on the list. And you have the voicemail there that shows that I clearly stated that this one's a paralegal, this one's an attorney, and I was just mistaken about that she was an attorney. I thought she was an attorney. And just subjectively thinking, I think at the time I had it in my head that she was somehow related to a firm that's familiar to me called Altman and Altman. And I think I might have just conflated that or something, but it was just an honest mistake. And Ms. Altman and Ms. Healy and a third one, Ms. Murray, have been wonderful paralegals, some of the best paralegals I've ever worked with on this case. And, you know, I just don't understand why or where Mr. Mello can stand up in front of the court and make a statement that Ms. Healy, for example, has never had any paralegal training. Like, are we going to really go into the issue of what the training is of these folks? I mean, Ms. Healy has taken college classes, just because he raised it. Ms. Healy's taking college classes for criminal justice, and she's amazing, and she's a terrific paralegal. In fact, I'm going to be hiring her for some of my CPCS murder cases to work as a paralegal.
Okay.
And I've actually got the ball rolling on that.
I think we're afield.
I'm sorry?
We're getting a little far afield.
Yeah, so I'm just trying to respond to the things that he raised, Your Honor. I'm sorry.
You don't need to respond to everything that he raised.
Okay.
I've read your papers. I understand your position, which is that it was an error on your part, that it was not intentional?
It was an absolute oversight, Your Honor. And at the time, I didn't know whether the fine points of their policy, whether it meant just lawyers or paralegals and investigators. And so in that situation, you just do full disclosure. I said to them, Captain Linsky was very professional and helpful. And they said, here's the people that are on our legal team. And a previous call, I believe I said it was Mark Geppetta, our investigator, and Ms. Dombrowski, the other lead counsel on the civil issues. And then on this call that's in counsel's filing, I said very clearly, Courtney Healy, paralegal, and again, Ms. Altman, I thought she was a lawyer. So I was not trying to deceive or hide anyone's status from anyone. I was putting it on the jail to do whatever they were going to do. And so I received a message, and that's in my affidavit, Your Honor, the next day, that everybody was on the list. And I thought that was great, and that we were going to be able to strategize and
all right. I understand your position, Mr. Bradl. Attorney Mello, the first request that you have of me in your motion is that the Norfolk County Sheriff be ordered to revoke the defendant's privilege of communicating with parties other than his counsel of record. Given the testimony that I have heard today, you want to stop his ability to use the tablet or the telephone in all respects.
Other than his children and Attorney Bradl, yes, Your Honor.
And what power do I have to do that?
Your Honor,
order the Sheriff's Department to limit his telephone privileges entirely.
The inherent authority of the court allows that, Your Honor. The court can certainly do that, issue that restriction.
But I thought your point was those would be monitored. All communications other than with counsel of record would be monitored.
They would be, Your Honor. However, what's come out thus far has certainly been harassing to some of the individuals. As I indicated, the victim who, in the last arrest that put Mr. Kearney in the jail, just online this week, indicating, this victim knows I'm innocent. And there have been a number of other elements of harassment. Mind you, this is the same defendant judge that has openly acknowledged in court that he wanted the opportunity to post DCF records about this particular victim in order to humiliate him for no other purpose. So he's still engaged in his campaign, if you will, of harassment and intimidation. And the original order was that came out from the district court in Stoughton. All those cases are now no pros. The purpose of the order was to stop him from directly or indirectly attempting to intimidate people. He's behind bars, Your Honor, and he's just as active as he was when he was in public.
But that's why I asked you at the outset, there is no order like that in this case now?
No.
Okay. Anything else then before I take this under advisement, Attorney Mello?
Your Honor, we do have the last, and this is an abundance of caution. I know it's unprecedented. We have taint teams being established in this matter for various telephones and electronic devices that have been taken. Obviously, Your Honor, the purpose of a taint team is to prevent the Commonwealth from viewing anything that would be considered to be attorney-client or otherwise prohibited to the Commonwealth that's on these devices. One of our concerns, Judge, with that respect is that we need, and this is what's unprecedented, the Commonwealth feels it needs a taint team of sorts that works in the present time. We are so concerned about Mr. Bradl's actual intentions, and the Commonwealth, I apologize, Your Honor, the Commonwealth does not concur with Mr. Bradl's position that it was an accident or an error. Certainly, that's something that at the very least should have been confirmed. So, again, the Commonwealth does not concur that it was an accident. Nonetheless, given the fact that Mr. Bradl made such a move, if you will, to have non-attorneys listed as attorneys, we're concerned that Mr. Bradl's motives may be to play up to the defendant's desire for this publicity that he has. And that if attorney communications with the defendant were unmonitored, Mr. Bradl could use those communications as an opportunity for third parties to be involved, to simply engage in the same types of unmonitored conversations that the jail's rules are intended to prohibit.
I don't know what you are inferring, that Mr. Bradl would put someone else on the phone?
Yes. That's a concern the Commonwealth has, Judge.
All right, so you are asking me to appoint somebody to monitor all communications between the defendant and his counsel in this case.
And only report to the court, not to the Commonwealth, Judge.
And under what authority do you make that request? Or is this entirely an unprecedented request?
Entirely unprecedented, Your Honor.
All right. Thank you. I understand what you're asking for. Attorney Bradl?
I'm completely shocked at what.
Okay, we don't need to start with.
And the idea that I'm doing something wrong is just so completely offensive to me. I can't even fathom, Your Honor.
Let's focus on my power and authority to do what the Commonwealth is asking me to do.
There's no power to do that, Judge, but I just can't sit here and have counsel level these charges against me without responding. I would never do anything of the sort. I never have done anything of the sort, and there's nothing but complete, utter speculation with respect to what he's saying, that they're worried that I'm going to do something with the calls.
All right, Mr. Bradl, so are you the only counsel of record for Mr. Carney in this case?
Yes, Your Honor.
Does he have other counsel in connection with other pending criminal matters?
No, Your Honor.
You are his only lawyer?
Yes.
All right. So I'm going to take this all under advisement, but I am going to direct you today to send a written communication to the Norfolk County Sheriff's Office indicating that you are the only attorney of record for Mr. Carney, and then file with the court an indication that you did so. All right?
Actually, Judge, now that I say that, there may be another attorney who is on. Is another attorney who speaks with Mr. Carney about First Amendment matters and advises him as well.
And where is he barred?
In Massachusetts, Your Honor.
He's a Massachusetts
Yes.
barred attorney?
Yes.
So
I have to look into it. I don't know. I'm just trying to be absolutely careful about everything that I say.
No, I want counsel of record in his criminal matters.
Okay, just.
So if Mr. or Attorney
Randazza, Mark Randazza,
if he wishes to be on that list at the Norfolk County jail, he'll have to enter an appearance in this case.
Sure.
So you are to communicate with the jail that you are the only attorney of record for Mr. Carney and report to the court that you've done so, okay?
Yes, Your Honor.
By the end of Monday.
Sure.
By the end of today, actually.
Okay.
Okay? All of the other requests that the Commonwealth is seeking, I will take under advisement, unless there's anything else you want me to understand.
Judge, there's quite a bit more in my motion that I want to bring before the court.
Okay.
With respect to Ms. Altman, Your Honor, I've only spoken to her a couple of times, and she was presented to me at the time as part of this team, and I gave it to the jail about who was what, and what they were going to do was up to them. I'm not responsible for their jail policies. I'm responsible for my client, and I wasn't sure whether people on the team could have those calls or not. So that's why I left it to the jail, and it's all on the voicemail, and there was nothing that was hidden or deceptive about it whatsoever. And after all this came to light, Your Honor, keep in mind, I never knew anything about Ms. Altman being called. I never knew anything about anything until counsel filed this motion. And which leads me to my next point, Your Honor, that I want to ask the court to strike the pleading. The pleading absolutely does not comply with the rules, and it does not have any affidavit, and there's no swearing whatsoever to it. And it was, again, continued here in court, where counsel's making these speculative, insane, unsubstantiated allegations about me and about Mr. Carney and everything else. Counsel likes to say what I'm aware of, Your Honor, okay? I'd like to tell the court what I'm aware of and what I'm not aware of. I had never met Ms. Altman at the time of this, of giving her name to the jail. And the conversations about when she talked to me about what she did and who she was, about her not being an attorney, were much later. And again, I did not equate those conversations with anything that I said to the jail in passing on a voicemail to Captain Linsky. So counsel files this motion, Your Honor, and publishes all of the phone numbers, all the private cell phone numbers of myself, Ms. Healy, and Ms. Altman. And as you can see in the motion, Judge, as a result of counsel for the Commonwealth doxing all of us in this public filing, Ms. Altman receives threatening text messages that absolutely scare the heck out of her and terrorize her, Your Honor. And in that respect, Your Honor, she is absolutely scared and horrified and intimidated. And I've spoken to her personally about that. And she has a copy of all my filings, Your Honor. And here we have this situation, Judge, where in the course of trying to say that I'm doing something wrong, counsel publishes these phone numbers and absolutely exposes Ms. Altman and Ms. Healy and myself to unwanted harassment. And in this case, in fact, as I published in the filing, Ms. Altman did receive that very night a number of obnoxious, threatening, harassing messages, and I published one of them for you so you can see what she was dealing with. And this is from counsel for the Commonwealth. Lawyers have obligations, Your Honor. Lawyers have obligations to not dox people, first of all, Your Honor, to not publish sensitive private information in pleadings. That was done here, and that is outrageous and that is unprofessional.
Are you asking me to seal? I know it's out in the public realm somewhat now, but are you asking me to do anything in connection with the Commonwealth's motion?
Yes, I would ask you, whatever we can do now is to seal it for now, so that at least it's from now on it's sealed and the private information is not public.
All right,
or at least that portion of it.
Any objection to that, Attorney Mello?
You know, I would just ask that the numbers be redacted.
Well, we will impound what has been filed, and if you would provide a copy with the numbers redacted, that can go on the public docket.
Very good. Thank you, Your Honor.
I find good cause to do so.
Thank
Attorney Bradl, anything else?
Yes, Your Honor. Judge. In this case, Your Honor, counsel for the Commonwealth has charged Mr. Carney with the exact same conduct, categorically, as he has done here to me, to Ms. Healy, and to Ms. Altman, with the results actually happening to Ms. Altman, unfortunately. I'm not going to go over the factual underpinnings of it, Judge. It's in my motion. But the same exact conduct is charged to Mr. Carney, where he's alleged to have held up a piece of paper on his YouTube show with phone numbers on it, and then called phone numbers, and then mentioned phone numbers on his show. And then that was to one of the troopers on the underlying Karen Reed murder case, Your Honor. And then the charging documents indicate, Your Honor, that Mr. Proctor, the trooper involved, received threatening messages, et cetera, et cetera. And that was the basis in the Stoughton court for a charge of witness intimidation on Mr. Carney. And here, counsel for the Commonwealth has engaged in the exact same behavior with the exact same results that Ms. Altman has received threatening messages.
And that's the basis of your request that I issue an order to show cause regarding recusal.
That's correct, Your Honor.
All right.
Counsel now has a personal stake in this case because counsel's committed the exact same, categorically committed the exact same conduct that he's charging my client with. It's just, talk about unprecedented. Mr. Mello likes to talk about what's unprecedented. What's unprecedented is that the prosecutor is engaging in the same criminal conduct that Mr. Carney is alleged to have engaged in. Counsel for the Commonwealth now has developed a personal stake in this case. Counsel for the Commonwealth is not a disinterested observer, an advocate for the Commonwealth interested in doing justice. Counsel for the Commonwealth has inserted themselves, has wrapped themselves in personally into the allegations in the case.
All right, I understand your argument.
So based on that, Judge, I think, I'm not asking right this minute that he be disqualified, but I'm asking that you issue an order to show cause and set up a hearing as to why counsel for the Commonwealth should not be disqualified in this case.
Attorney Mello, how much time do you need to respond to that request?
Which one in particular, Judge?
The request that I issue an order to show cause regarding recusal.
I believe that Mr. Bradl has put 14 days in his motion. I believe he requested the maximum within 14 days. I'd ask for the 14 days, Judge. And if I may, Judge, there's a huge distinction.
Well, wait a minute. So you're saying you will file something in response by February 9?
Yes, please.
All right. When I receive that, I'll make a determination about whether I issue an order to show cause and whether we have an evidentiary hearing.
But if I may, Your Honor, the distinction that Mr. Bradl, between the facts and what Mr. Bradl is saying, Mr. Bradl is indicating this was doxed. The reality is the telephone numbers here were absolutely relevant to this matter. This wasn't a gratuitous publication of telephone numbers of individuals. This is a publication to the court. This was a filing with the court. It was not an outside filing. It was not a press release, whatever. It's a filing with the court of the numbers that Mr. Bradl indicated were attorney numbers.
That's a lie, Your Honor. I did not indicate they were attorney numbers.
Don't interrupt. I've read what you indicated. Go ahead.
And Mr. Bradl indicated they were attorney and paralegal numbers, Your Honor. He published that to the jail, okay? As a matter of our motion, that was absolutely relevant and part of our motion. Had it been a different number, whatever the case may be, it would have been inconsequential in terms of the motion. Mr. Bradl made those numbers known. As part of our motion, they were very relevant. And the motion could not have flown otherwise, Judge.
All right. I appreciate everybody's arguments. I understand everybody's arguments. Let me tell you how I have endorsed what is in front of me at the moment. The Commonwealth's motion for remedial orders and sanctions has two endorsements. Number one, counsel for Mr. Carney is to inform Norfolk County Jail by the end of day today that he is the only attorney of record for Mr. Carney at this time, and report to the court in writing by close of business Monday, January 29th, that he has done so. Second order on the motion for remedial orders and sanctions. Upon oral request for good cause, paper 4, the Commonwealth's motion, is impounded. Counsel for the Commonwealth to file a redacted copy for the public file. Mr. Bradl's cross motion is endorsed. Commonwealth to respond to cross motion on or before February 9, 2024. With respect to the Commonwealth's other requests for relief in the motion for remedial orders and sanctions, I will take those under advisement.
Thank you, Your Honor.
We have a 2/16 date for pretrial conference too. Thank you.
Thank you all.
Court will lie, please.
Totally unrelated.
Yeah. Yeah, thanks. Could I have the warrant brought in?
Hey, Steve.